In part 4 of the pet directive, you are going to lay out how you want your pet to be cared for after your incapacity or death. Now, I know this is not a fun subject. No one wants to think about themselves being incapacitated or having left this world, but I'm an estate planning attorney. This is what we do. We've got to get this information down in one place, and this is the spot to do it. So if something were to happen to you temporarily, is there a temporary place where you want the animal to go? Maybe it's a friend or a neighbor in the same town, someone who is fine to take your animal for 2 or 3 weeks. Say if you were in a skill facility getting rehab. So go ahead and put, a first choice and a second choice. The thing to keep in mind too, which I should mention, is that if you're co-owners of an animal, so my husband also owns our 2 dogs, this is only if both of us couldn't do it. Because clearly if something were to happen to me, my husband is the other co-owner of the animal. So this is only after both of us are no longer to care for the animal. If something happens to you and you have to go somewhere where you can no longer be home and you can't take a pet, where is the permanent place that you would like your animal to go to find a loving, happy, healthy second home? And so again, we put a first choice, a second choice, and a third choice if you can. And this is just like estate planning for humans. I find sometimes clients, years ago with another attorney, will only put one backup. And, this is a kind of a cul-de-sac because sometimes your one and only person is not available. And so you always really want to think about a backup person if your first name person is unwilling or unable to do it. What about giving your pet back to the breeder? As I had mentioned in part 1 of the form, some of my clients had said, I got my animal from a breeder, and if something were to happen to me, that breeder not only needs to be notified, but they have the first right of refusal to take the animal back. So it's really important to mark down whether you have signed a contract of that nature, so whoever is picking up, this directive and looking at how to care for your pet can follow any prior contracts or written instructions that you have signed yourself up for when you originally got the dog. If you want to take your animal with you, if you have to go live in an assisted living facility and you want that animal to come with you. Some places take animals and some don't. So it would be important to mark down whether that's a preference of yours, because a lot of people would love to take their animals with them if they had to move out of their home to a new / unfamiliar environment. And last, you should put down if you have left any specific instructions or bequests in your estate planning documents. So as an estate planning attorney, clients have put monetary bequests for their animals. They have put specific instructions about the care for the animal. And so if you have left instructions in actual legal documents, this is the place to let someone else know, hey, I've left other instructions. The thing that you should keep in mind is that this is not to supplant and is not a standalone legal document. This is to supplement, to add information, to provide resources to someone. This is not intended to be an actual will or a place to put a bequest. Some states have restrictions on whether or not you can do that. And so you should consult an attorney to see whether that information can be put in your own estate planning documents. And as much as possible, I know this sounds kind of basic, but you should make sure that this information and anything that you had put into prior estate planning documents don't conflict, because we want to make this as clear and easy as possible. And if there are conflicting instructions, then you want to make sure to have that information coordinated. So I hope you found this video on part 4 helpful. Thank you so much for watching it.